The next matter is Scott versus Kahn. The next matter is Scott versus Kahn. Counsel, whenever you're ready.
Good morning, Your Honors. May it please the Court. I am Dave Domina. I'm here on behalf of the personal representative of Brandy Block's estate. This case has been here before. The Court concluded that there was inadequate proof of wrongful death, and dismissed that claim. The Court remanded this case for consideration of the conscious pain and suffering claim by the trial court. Our position here is that all of the elements of proof of the tort of professional negligence, including the element of proximate cause of conscious pain and suffering, are present in the record that you have before you. Most of those elements are uncontested. There's no question that the physician at issue here had a relationship with the patient. There's no question about the standard of care. The standard of care is conceded. There is abundant evidence that in many different respects the standard of care was violated. The issue is proximate cause. I want to direct you to the deposition testimony of Dr. Carl Greiner, who is the patient's expert witness. At page 43, beginning at line 5, and with your permission, I'd like to read you the exchange of question and answer on that page. The witness has just testified about the standard of care for providing medication, and the question is, okay, but it doesn't have anything causatively to do with the woman's death. Then what relevance does it have? The answer is, well, it speaks to the appropriateness of her care, irrespective of the mode with which she died. Question, but that deficiency, as you define it in the standard of care, doesn't have anything to do ultimately with what resulted in this case, which is the woman's death. And here's the critical answer. Well, there are many outcomes for this young woman. In fact, she died. There's also the question of the appropriateness of her treatment at each point in her care, and that if someone were continuing to suffer psychiatric symptoms or have worsening psychiatric symptoms when they could have been managed, that is the problem of psychiatric care, whether or not it resulted in death. This woman...
Excuse me, Mr. Domina, is that from the first deposition?
That's from... There are two reports of this witness. There's only one deposition.
Okay, so this was the deposition that was taken prior to the first motion for summary judgment.
That's correct, Your Honor. And there was no subsequent deposition. There is a subsequent affidavit and report, which I'll address in just a second.
I'm assuming that recitation is in connection with your argument that even if the court properly excluded that second report, there's sufficient evidence in the deposition to go to causation for pain and suffering.
That's precisely correct, Your Honor. We believe there is. And that brings me to the second affidavit, because I have nothing more to say on the question of whether the record without Exhibit 25, the second report, is sufficient. I think it is clear that it is sufficient. There is a causal connection between the mismanaged psychiatric care of this patient and her conscious pain and suffering without the affidavit. The affidavit, Exhibit 25, which was prepared after your remand order and offered in evidence before the second hearing on the motion for summary judgment, adds virtually nothing to the record except to crystallize causation. It says that in the physician's opinion, Dr. Greiner's opinion, this patient suffered physical, emotional, and mental distress as a proximate result of professional negligence. The very week I assisted this witness with that affidavit, I was attacked for writing expert witness reports in another case, for helping the witness with the legal language. We've come to a point where what the defense has as a handy tool is to say, if it sounds too legalistic, the plaintiff's lawyer did it. And if it doesn't sound legalistic enough, then the record's not adequate. And that dilemma is not fair to the patient. So I submit that what this court ought to do is this. Find, number one, that the original record was adequate on this part of the claim. And find, number two, that the court could have considered Exhibit 25, which did nothing more than crystallize, did nothing more than accumulate the evidence of the witness previously, and would have been proper for that reason, and you don't have to wrestle with what the nature of your remand order was.
If we find that the original evidence that was submitted at the deposition is sufficient to raise a question of material fact, then to go to that next step, wouldn't that just be dicta? I mean, it's...
Yes, it would. Yes, it would. And the only value the dicta would have, and the value that dicta generally has, if it has value, is to allow persons some guidance at what remand orders are. I don't read your order in this case, and I may misunderstand it, as an order of specific remand. You did not say this case is reversed and remanded for consideration of the motion for summary judgment as originally submitted. You said reversed and remanded for further proceedings. Those further proceedings could have included a request by the plaintiff for additional time to take more deposition testimony, to investigate the record with further discovery, to amend the pleadings, even to dismiss the case and refile. And all of that, I think, was within the ambit of your original order. The trial court believed that your order, and was persuaded that your order meant thou shalt consider the summary judgment motion as originally submitted. I think the jurisprudence that would be assisted with dicta, Your Honor, would be to say, look, when we issue a specific remand, it's going to be a thou shalt do specifically this order, and it's not going to say reversed and remand for further proceedings. So if you decide on adding the dicta, from the practitioner's perspective, I think that's the value it would have.
Did I understand you, or perhaps misunderstand your previous comment that to determine that Exhibit 25 was admissible, we don't need to discuss the meaning of the remand?
Oh, pardon me. No, I think you do need to discuss the meaning of the remand.
Then I misunderstood a comment.
Well,
thank you for clarifying.
Thank you. And I have nothing more. I'll save my time.
Thank you very much.